Hello and welcome to topic 10, lecture 2. And in this topic, we're going to be learning about the legal rights during trial. Okay, so what are we going to be covering in this lecture? Well, first, we're going to think about criminal trials in relationship to democracy. We did the same thing when we were learning about policing. And so we're going to make sure that we think about criminal trials in relationship to democratic society. And in doing that, we're going to talk about the importance of this concept called due process. And then we're going to take a look at where we find due process, right? And where we find the embedment of protections of the rights of the criminally accused in the Constitution. And so in this lecture, this isn't the extent of all of the constitutional protections for the criminally accused, but it's the bulk of them. And so we're going to be taking a look at the Fifth Amendment, the Sixth Amendment, and the 14th Amendment. And so I'm going to leave it to you to read about the actual trial process in the textbook. So, opening statements, presentation of, witnesses and evidence, etc. Okay, jury deliberations, etc. So I'll leave it to you to read about that in the textbook. Here we're going to be talking about sort of the constitutional rights that are afforded the criminally accused during trial. So let's go ahead and get started. So just as it's easy to do policing and to arrest people within an authoritarian regime, the same is true when it comes to convicting a person of a crime. It's easy to try and convict a person in an authoritarian regime or authoritarian style of government. And just to be clear, I think I've mentioned this before, but the authoritarian government is a type of government that has no real formal limits on their power. Okay, they basically do whatever it wants. As it says there, that in an authoritarian government, there are no legal limits on their power, and that the accused has no trial rights. And so basically, when it comes to an authoritarian regime, conviction of somebody of a crime is basically a sham. Anybody can be charged for any reason. You don't need to have probable cause. That you don't need, that anyone can be found guilty or acquitted because there's no protections to make sure that the jury that's hearing this case is going to be unbiased. You might not even have a right to a jury trial. You might have something in front of a judge who does not have to be unbiased, counsel doesn't have to be afforded to you. Heck, you don't even need to be told what, crime you're being charged with. The list kind of goes on. And so it's easy to try and convict somebody in an authoritarian regime, but that has nothing to do with justice, okay? Because there are no limits that are placed on the power of the government, and there are no fundamental rights, individual rights, that are protected in authoritarian regimes. Well, it's obviously a lot harder to convict a person in a democracy, in large part because in a democracy, there are clear limits that are placed on the power of the government, and the accused has a robust trial rights and other rights that are afforded to those who are accused of crimes. And that's what we're going to be talking about in this lecture. And so in a democracy, conviction is much less hollow, because when somebody is convicted of a crime, then we know that, that the person accused of the crime has been given certain rights. And also the government can't do whatever it wants in order to get that conviction. The government can't, just bust into your apartment or your home without probable cause. If they can't manufacture evidence and submit it in a court of law, that they can't hand select a jury that's going to give the government the outcome that they want, etc. And so that because there are these limits that are placed in the power of government, it makes a conviction less hollow. But obviously, it's far from perfect. Yes, the accused have rights, but oftentimes the accused have had to historically and continue today have to fight to make sure that these rights are abided by. And this is definitely the case for those who are poor and in a minority group, because you can fight for your rights. However, if you don't have the money to hire a great defense attorney, then you oftentimes get a public defender. And even though public defenders try their hardest to give somebody a great defense, that the reality is that they are underfunded and under a lot of stress. we also, and making it, the right to counsel a little bit more difficult for those who do not have money. That when when it comes to selecting a jury, that we know that bias is still present, etc. So that the accused have to fight for their rights, and that those rights are not always equally applied, and also that, as we saw in the first lecture, that those people oftentimes waive their trial rights for a variety of reasons, and so they will end up agreeing to a plea bargain, and which is essentially waiving their rights, so that even though you have those rights, some people, not even though they may not be guilty, that they waive those rights because the consequences of being detained in jail when pending trial, and also not having confidence that you're actually going to be acquitted, can lead you to waive your trial rights. So bottom line is that while trial conviction is less hollow in a democratic society, it is far from perfect, obviously. Okay, so let's look at the United States Constitution and where we find trial rights in it. And so we're going to take a look at the 5th and the 14th Amendment, and then we'll also take a look at the 6th Amendment. Okay, let's turn our sights to the concept of due process as it relates to trial rights in the United States. Now, that when we've talked about due process during the course of this semester. We've talked about it in relationship to the due process perspective, but we've also talked about due process as it relates to law enforcement as well. But just to refresh your memory about what due process is, that due process is the assurance that all levels of American government must operate within the law and provide fair procedures. So we've talked about in the past that everybody is subject to the law, and that includes government actors as well. And that also that fair procedures need to be followed, particularly when government is doing things to you that are quite harmful. And so that when we talk about due process, that due process is embedded in the Constitution. So due process is this idea that government needs to operate within the law and fair procedures, and that is such an important concept for democratic society that it's embedded twice in our Constitution. Once in the 5th Amendment and once in the 14th Amendment. So I'll just put both of these up here at the same time, and then we'll talk about why these are in our Constitution twice. So in the 5th Amendment, among other things, it's actually an amendment that has several liberties in it. That one of the things that's in the 5th Amendment is what's known as the Federal Due Process Clause. And it says that no person shall be deprived of life, liberty, or property without due process of law. So in other words, if the government is trying to take away your life, your freedoms, that's your liberties, or your property, they have to do it in accordance with the law and using a fair and known procedure. And so, taking away your life, the death penalty, the government can do that, but they have to use fair procedures. And when we get to the death penalty, you're going to find that there have been times when the government was found to not use fair procedures for implementing the death penalty or sentencing somebody to death. So we've actually are going to see that they've made changes to the way we sentence people to death by having a guilty phase of the trial and then the sentencing phase of the trial to make sure that the process is more fair. That we also see that government can take away your liberty, obviously, if you're incarcerated. But also they can take away your right to free speech or your right to exercise your religion as long as they do it according to a fair procedure. And property too. Government sometimes takes away your property, and they might need to do that for a really good reason, like they need to build a highway or something like that. But they need to do it in a fair way, right? And so that usually if your property is taken away, that you're given market value for the property that is taken. And even when it comes to law enforcement can take away your life, can shoot you, kill you, but they need to do it in a way that's fair, right? So, and that's where the idea of excessive use of force is. Police can use lethal force if there's a fair reason for doing it. Somebody has a machete, a machine gun, they're running down the street. It's fair that the law enforcement use lethal force to stop that individual, because that individual could, represent great harm. But if you're using excessive force in a way that's not necessary or needed, then that's unfair. Okay, so we sort of see this idea of due process in the 5th Amendment. Now, we also have a due process clause that's in the 14th Amendment, and it's almost the same as the 5th Amendment, but that it has a little bit of a twist. The Due Process Clause in the 14th Amendment applies to the states. And the Due Process Clause in the 14th Amendment was added after the Civil War in 1868. And it basically is telling states what they can't do. Okay, so the Fifth Amendment is seen as applying to the actions of the federal government. The 14th Amendment is seen to apply to the actions of the states. It says, no state shall deprive any person of life, liberty, or property without the due process of law. And so that embedded in our Constitution this robust protections for due process. States can't take away life, liberty, or property. Neither can the federal government without following the law and fair and just procedures. Now, keep in mind that due process is a constitutional guarantee. It's kind of abstract. Just because there's something explicit, just because it's not explicitly stated in the Constitution, doesn't mean that the government can engage in that action. So let me give a concrete example. There's nothing that says that in the Constitution that explicitly prohibits like a biased judge or explicitly states that counsel must be competent. I mean, it basically says that you have the right to assistance of counsel, but it doesn't say anything about that your counsel has to be competent. Well, if your counsel's not competent, it's not due process, right? Because it's not a fair procedure. Sure, you got counsel, but your counsel was drunk or didn't know the law. Well, that's not counsel. So due process is this broad constitutional guarantee, even if it's not explicitly stated in the Constitution that you get a right to an impartial judge or you have a right to competent counsel. It's in there because it violates not having that would violate the Due Process Clause. Okay, let's turn our sights now to the Sixth Amendment. And the Sixth Amendment is a really long amendment. You'll be learning more about it in your textbook, but it's really in the Sixth Amendment where we find the rights for a trial, your trial rights. And so it says in all criminal prosecutions, so keep in mind the Sixth Amendment applies to criminal law, not civil law. But in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. We'll talk about what that means in a second. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And so that is the Sixth Amendment. And that is a lot of rights that are given to those who are accused of a crime. You can see that the arraignment is there, informed of the nature and cause of the accusation, right? That's where you are, told of the crime you're being charged with. But the other ones are, we need to go into more detail with those because we haven't covered those in class. So let's go quickly over some of your trial rights that are listed in the Sixth Amendment. Whoops, I forgot. Before we go with the Sixth Amendment, there's another really important trial right as well that is found in the Fifth Amendment. So we're back to the Fifth Amendment. In the Fifth Amendment, we know this, but I wanted to make sure we brought it up. It's this that you have the right to refuse to testify. Now, remember that you have the right to remain silent as it relates to law enforcement. And so the Fifth Amendment applies to law enforcement. But the Fifth Amendment also applies to trial rights as well. And so the Fifth Amendment says that no person shall be compelled in any criminal case to be a witness against himself. In other words, you cannot be forced to testify. And if you don't testify, if you don't make testimony, if you say you want to remain silent, it can't be used against you. The jury cannot consider the fact that you didn't testify on your behalf when they're determining whether you're guilty or not. And so the right to remain silent, the right to refuse to testify is also an important trial right. So when learning about the trial rights, ask yourself, how do these rights satisfy the promise of due process that we were just talking about? In other words, when we dig into these rights more deeply, ask yourself, how do these rights provide assurances that the trial procedure is fair? Another thing I want you to keep in mind is that the Sixth Amendment rights are broad and underdefined, right? So when it says assistant to counsel or a speedy trial, those words are in the Sixth Amendment, but we're not exactly sure like what that means, like what constitutes a speedy trial. Like, do you have to have a trial in 5 days or in 500 days? When it says assistance to counsel, does that mean in all aspects of the criminal trial? So while you're learning about these rights and we go into more depth about them, I want you to keep in mind that it's the Supreme Court of the United States who often plays the role of defining what certain phrases in the Constitution mean. And also law, both state law and federal law, can also provide for more robust definitions of these rights and procedures. So let's now take a look more deeply at what these different rights that are outlined in the Sixth Amendment actually entail. Okay, so according to the Sixth Amendment, the defendant has a right to a speedy and public trial. And so that means that trials will take place in a public arena, a place that is open to the public. And one of the things that I've noticed from students is when they go to do their courtroom report, is that they often feel like out of place, right? When they go to the courtroom, when they enter into the courthouse, they sort of feel like they don't belong there. And I always remind my students that trials are public and that they are open to the public, and they're open to the public for a reason. And that reason is that you're more likely to have a fair procedure. In other words, due process is easier to take place when we can actually look at what's going on. If courtrooms were not public, well, the people who work in courtrooms could say that what's going on is fair procedure and that they're following the law, but how would we really know? And so that the wisdom of the framers, including this in the Sixth Amendment, they say that trials are public, that the people can come, and being able to see what's going on basically is an effort to hold the court system more accountable. It also says that you have the right to a speedy trial. And so, the question has come before the court, well, what constitutes a speedy trial? Now, usually the speedy trial concern is not when a defendant is asking the court for more time to prepare their defense. That's up to the defendant, right? If the defendant feels like they need more time and the court grants them that time, then, that time can be taken to prepare for your defense. The greater concern is when the government is not acting in a speedy manner for a trial, when they are waiting and waiting and waiting to try somebody. And there's a problem with that. I mean, the state might be waiting for, a key defense witness to die or something, right? Or they might be hoping that the longer that they wait, that any defense witnesses that you bring, that they might not remember quite as well in terms of defense. And also, I mean, from a prosecutor's perspective, while there might be a benefit to waiting to have a trial, that benefit might be that if it takes too long to have a trial, somebody will just say, forget about it, I'll plead guilty, right? But also, if you don't have a speedy trial, then the prosecution could also, that evidence would not be as crisp in in terms of the witnesses testifying. So a speedy trial. But what does a speedy trial mean? Do you have to have it in a week after you're charged? Do you have to have it in a year after you're charged? What is a speedy trial? Well, that the Supreme Court has answered the case about what a speedy trial. They sort of wade into that, trying to define that. And that the way the courts have defined it has gotten translated into state and federal law. And so, for example, in Wisconsin, our laws tell us that for a misdemeanor, the trial must take place 60 days from the initial appearance in court and 90 days for a felony, okay? Now, that doesn't mean that it must take place 60 or 90 days. If the defense is asking for a continuance and more time to prepare, they can have that. But if the defendant wants the trial within 60 days, then they're going to get the trial in 60 days. The government cannot drag its feet. Even though the Sixth Amendment doesn't say anything about a judge, it says that you have a trial, a jury trial. It's assumed that there is a judge, and that judge, the court has said, must be impartial. If there's any indication that the judge has like a particular interest in convicting an individual, or a particular interest in exonerating an individual, right, then that would not be impartiality. So the judge must be impartial. And if there's evidence that the judge isn't being impartial, then that could be cause for either a mistrial or more likely an appeal. And also that if you choose to have a jury trial, exercising your right to a jury trial, that the jury must be impartial, and that the jury also must be selected from the district from which the crime was committed. Okay, so sort of like a jury of your peers is that this is where the crime took place. And so the people from that area will determine the guilt or not guilt of that individual. Now, you don't have to have a jury trial. You could waive your jury trial rights and say you want a bench trial just in front of a judge. You can do that. However, and also not all offenses have a right to trial, but it is usually a more significant or serious offense that you will have a right to trial. So the Supreme Court has said that anyone who faces a sentence of 6 months or more has a constitutional right to a jury trial. Okay, if the penalty is less than 6 months, that the constitutional right doesn't necessarily kick in. So that's what the Supreme Court has said. And to assure that it's going to be an impartial jury, there's a series of rules that you can read about in more detail in your textbook. That making sure that the jury comes from the area where the crime was committed. You have the jury pool, the veneer that's pulled from that district where the crime took place, the county usually, or the municipality. Voir dire is a process of questioning the jury pool to make sure that the jury is not biased or has an interest in an outcome of the case. And then to make it fair procedure, that any juror can be dismissed from serving on the jury for cause. Let's say that they know the defendant, or let's say that they, sometimes if that, let's say there's a member of law enforcement and that's, a part of the case, and that person, then you could be dismissed for cause. But they also have these challenges that you'll read about in your textbook called peremptory challenges. And that's just that you can say that you don't want a person to sit on a jury for no reason. You don't have to provide a reason, okay? And that usually each side gets the same number of peremptory challenges, just saying, no, we don't want that person on the jury, but they don't have to provide a reason to make it fair. However, even if you are dismissing somebody and there seems to be a pattern of bias, like you're dismissing all the women, or you're dismissing all the white people or all the black people, then that is seen as a violation of a person's Sixth Amendment jury rights. All right, continuing with legal rights during a trial, that you have a right to be competent at your trial. And the reason for that is that convicting a person that can't participate in their defense because they're incompetent is unfair. And so if the defendant is suffering from a mental disease or defect, they're not going to be able to help their counsel, their defense attorney, to actually mount a really vigorous defense to defend them from these charges. They have to be able to competently engage with and talk with their attorney. They have to be able to tell the attorney about evidence or other information that's going to help them defend themselves against these charges. And if a person is incompetent and unable to do that, then basically they cannot have a fair trial. Now, that doesn't mean, so if you are found to be not competent to be tried, then there's basically a pause on your trial until you are at the point where you are deemed by the court to be competent. Now, an individual can't not take their medications, like antipsychotic medications or antidepressants, in order to remain incompetent, in order to basically circumvent the trial. The courts have said that the court can intervene and actually force the person to take the medicine in order for them to become competent, okay? But bottom line is you must be competent for trial. You have the right to be present at your trial. You don't have to be present at your trial, but it's probably best if you are present and hear the case against you. Obviously, if you didn't have the right to be present at a trial, that would violate due process, because then you wouldn't be able to hear the case that the prosecutor is making against you. And if you didn't have counsel, you couldn't defend yourself if you're not present. But even if you did have counsel, that you need to be there in order to make sure that your counsel is doing a good job. You have the right to confront witnesses, and so that when prosecutors bring witnesses to testify against you, you have the right to confront those witnesses. And in the Sixth Amendment, it talks about that you have this right to confront witnesses. It's called the Confrontation Clause. And basically what that means is that the defendant gets an opportunity to cross-examine prosecution witnesses. And the hope is that this prevents hearsay testimony. And so, for example, if a person is basically saying, I was there, I saw the person accused of the crime stab somebody, right? Well, then the person who's defending themselves can say, you weren't there, right? Because I was there, I didn't see you. And then it might come out that, oh, yeah, well, I actually didn't see you stab somebody, but my friend told me that you did, okay? So because you have the right to confront that witness and ask them, were you there? Were you present? Right? Then it's going to make sure that hearsay testimony is not admitted, because that is not allowed in a court. And the way we find that is by allowing the witnesses to be confronted by the defense. You also have right to a compulsory process. And what that means is just as you have a right to confront the witnesses of the prosecution, that you have the right to secure witnesses in your favor, okay? So that it levels the playing field, making it more fair and more in alignment with due process. And so that defendants have the power to subpoena a person to testify, just as the prosecution has the power of subpoena, so does the defense attorney. They can subpoena people to come and act as a witness for the defense. So the Sixth Amendment states that the accused have the right to the assistance of counsel for his defense. And, basically that means that defendants have a right to counsel. But what exactly does the right to counsel mean? Does it mean that even if you can't afford an attorney, the state must give you defense, must provide for your defense? Well, initially, that wasn't the way that the Sixth Amendment was interpreted. Initially, the Sixth Amendment said that you have the right to the assistance of counsel, but that means you've got to provide that counsel on your own. You've got to hire somebody to, provide you your defense. But the Supreme Court sort of, cases begin to come to the Supreme Court as people who are poor, who cannot afford attorneys, then the Supreme Court begins giving us a better understanding of what that phrase, the assistance of counsel, actually means in the Sixth Amendment. So one of the first cases that the Supreme Court hears about the right to counsel is a landmark case called Powell versus Alabama, which is, you might have heard about this case. It's about the Scottsboro Boys. It's about a group of African-American young men, teenage boys all the way up until young adults. And it's during the Great Depression, and they are riding train cars. They get on a train car, like a freight train car, and for a free, trip. They're basically train hoppers. And that when they get on the train car, there is a group of white kids on the train car as well. And then when they get off near Scottsboro, Alabama, that the white kids on the car accused the black kids of raping the girls who were on the car, the white girls. And so these young men were all charged and brought to court, getting ready for trial. But they didn't have counsel. And in fact, they weren't properly provided with counsel. And so the question in Powell versus Alabama is like, do you have a right to counsel? And what the court said is that in certain circumstances, you do have a right to counsel. And in this circumstance, that the poor did have a right to counsel in capital offense cases. And at that time, you could get the death penalty for being found guilty of rape. Okay. So first, that you had a right to counsel, but it had to be for a really, really serious offense that where you could get the death penalty, and also you needed to be poor. Then the court moves on from there and expanding it a couple of years later in 1938 in the case Johnson versus Zerberst. And in that, they said that any poor person has the right to counsel, but only in federal offenses. Okay, so it's sort of like, hey, if you're charged with a federal offense, then the poor have a right to counsel, regardless of the seriousness of the offense, right? So it could be for any federal charge. And then in 1963, in the landmark case Gideon versus Wainwright, that the Supreme Court really expanded the right to counsel, saying that all poor have a right to counsel, not just at against federal offenses, but against state offenses as well. And again, remember, you had that extra credit opportunity where you can watch the documentary called Gideon's Army about the public defenders. So today, defendants, including juveniles, receive robust rights to counsel. That you get counsel if in any capacity, if you're found guilty of the charges, if your freedom can be taken away as a part of the sentence, even if it's just like the possibility of a 12-hour incarceration, you have the right to counsel at your trial. Now you can, so we have a robust level of rights. You can waive those rights, but it's really not advised. In other words, that you can waive your right to counsel and represent yourself, which is called a pro se representation. But you're really counseled against doing that because even if you are a really good attorney, you're not really suited to provide defense for yourself. You need an outside counsel to help with that. And the final right that we're going to talk about is that even though it's not in the Constitution, the due process says that to be convicted, that the government or the state, whether it's the federal or the state government, needs to prove each element of the crime beyond a reasonable doubt. That means you don't have to have absolute certainty that this person is guilty, but that you have to have like little to no doubt that this person is guilty. And so, again, it's the standard of proof in criminal trials is high, beyond a reasonable doubt. Now, there are other legal rights that you're going to be reading about in your textbook, so I'll leave it up to you to read those rights. And as you're learning about these rights, just keep in mind about how all of these rights relate to trying to achieve due process as outlined in the 5th and the 14th Amendment. Okay, that's it for this week. Thanks for listening, and I'll talk to you again soon.